Okay, well, I do believe that I am live right now. So if that's the case, welcome. Hello, everyone. Thank you for joining me. My name is Lior Samfiru. I'm the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP. We're the biggest employee side law firm in Canada. We operate in BC, Ontario, and Alberta. And the reason why I am here right now, live, by the way, is to answer your questions. To answer your questions about employment law, about workplace rights, to make sure that you understand how to deal with any ultimatums that you've been given, suspensions, layoffs, leaves, being let go, threats, whatever the issue, whatever the employment scenario that you are facing, there's answers, there's solutions, and it starts right now, right here, by you asking a question live of me. So if you have an issue that you're struggling with, type it in, press enter, I'll see it, I'll read it and answer, and you can walk away having all the answers that you need to. Now, let me also give you some other contact information. If you want to connect with me off air, off social media, you want to have a private chat with me, you want just you and I to chat, not a problem, easy to do. All you do is you go to employmentlawyer.ca. You see that address below me, employmentlawyer.ca. You have phone numbers there, email addresses there. You can submit a form. Everything you need is right there to connect with me. So if I don't answer your question, I don't get to it, or you don't get to ask it, don't wait until the next time I'm on. Contact me right away. Let's solve your workplace problem. There's solutions. Employment laws are good. Employment laws are here. We have some of the best employment laws in the world in Canada. So let me tell you what they are. So again, my name is Lior Samfiru, partner with Samfiru Tumarkin LLP, and I'm here answering your questions live. So, and by the way, Justin, yeah, we're only talking Canadian law exclusively, specifically Ontario, BC, and Alberta. I'm going to start answering some questions. You got time, guys. Ask your questions. First question from Ashley. It's a bit of a long one. Let's see if I can get through it. I'm on a medical leave of absence due to mental health that has been caused by my manager from her unprofessional conduct. My doctor does not want me to go back to work for the company, as my doctor states it's a toxic environment. The company does not offer any benefits or pension. They don't offer anything except for vacation days and sick days. I've been there for 3.5 years and now on medical leave for 4 months. Never signed an employment contract. Am I entitled to severance? So, first of all, severance for you would probably be about 5-6 months paid. But to be entitled to severance, Ashley, you have to show that you've been subject to a poison work environment. Keep in mind, your manager is not going to admit it, right? Your manager is not going to put up her hand or his hand and say, yes, I did it. So you're going to have to be able to show it. If you have a way to show it, there's emails, there's recording, there's witnesses, there's some way to show it, then absolutely. The fact that you were subject to this harassment or bullying, whatever you want to call it, is what we call a constructive dismissal. By doing that, your employer has essentially terminated your employment, and now you are owed severance. The problem is, if you can't prove that and you choose not to go back to work, then that's just a resignation and you're not going to be owed anything. Okay? So the key is, how do you prove it? One consideration may be this: if you can't prove it now, if you don't have proof, is to go back to work and to start documenting things. If something is said or something is done to you, to build that case against your manager and then pursue your severance, okay? So if you can prove it now, let's get to work now. You can contact me. You're probably looking as much as 6 months severance. But can you prove it? That's the real question here, Ashley. Thank you for that. Feel free to do a follow-up questions or to contact me directly through employmentlawyer.ca. Okay. From G, is the removal of the mandates for restaurants helping the cases for those terminated because of not getting vaccinated? Absolutely, yes. So the fact that governments have decided, many governments, not all, but many governments have decided that, you know what, we don't need vaccine mandates, it doesn't need to be mandatory, is definitely helpful to those individuals that are pursuing cases against their employers because they were either let go or put on a leave because of their vaccine mandate. So yeah, absolutely helpful, because the government is now concluding, you know what, it really wasn't that necessary, okay? In other words, being vaccinated is not necessary to stop the spread of the virus. If it was necessary, you would think they would still mandate it. So yes, it is helping, and we've already settled and resolved many of these cases. We're resolving them all every day. We have hundreds of these across Canada. If that is your situation, if you've been let go or put on a leave because of your vaccination status, we need to connect right away. Let's do that as soon as possible. And again, employmentlawyer.ca, the way to do that. Next question from the Dreamer. Can an employee receive severance if the place of business has been temporarily closed due to renovations? Absolutely. I think I misunderstood the question. If your employer decided to do renovations, okay, and because of that, they shut it down and you're off work, you absolutely can treat that as a termination. It's your employer's decision. On the other hand, if there was an act of God, maybe the building was damaged and now your employer has no choice but to close to renovate, then no, because it's an act of God that's not in your employer's control. But if it's something that they decided to do, yeah, you can treat this layoff, if you will, as a termination and get severance. Absolutely that you can. So is it your employer's choice or is it something that was beyond their control? That's the question. Guys, by the way, those joining us, welcome. First of all, my name is Lior Samfiru. I'm the employment lawyer, and this is the employment law session. You're here asking questions and learning about employment law. You see how easy it is. You ask the question, I answer it, you walk away with that information. You got some time. We always get a lot of questions at the end, and sometimes I can't get to them. So don't wait till the end of the session, okay? Ask your question right now while there's still time. Next question from Tammy. Can an employer use Section 63 that my injuries were unforeseeable, therefore they do not have to pay severance? Employer failed to accommodate? No. So it doesn't matter, foreseeable, not foreseeable. If you lose your job, well, first of all, I'm not sure exactly why we're talking about severance. The fact that you're injured doesn't mean you get severance. You get severance if you are let go. If they let you go because of your injuries, then sure. If they don't let you go, but you have to be off because of injuries, then no, you're off and you're going to work to get better. And at some point when you return, they have to try at least to take you back to work. So it's a question of what's happened to your employment status. That's really the issue when it comes to severance. Okay. Next question from Gazia. I was put on a leave of absence since February 1. Been working for the company for 22 years. What's my option? So, Gazia, assuming you're not part of a union, you have only two options. Option number one is you don't do anything and you wait and you keep your fingers crossed that at some point your employer calls you back to work. That is option number one. Option number two is you can treat your employment as being terminated. You can say that by putting me on this leave effective February 1, I think you said it was, you've terminated my employment. Now you have to pay me severance. And for you, after 22 years, you could be looking at as much as 2 years severance, 24 months pay, okay? So if that's what you want to do, Gazia, if you decide to treat your employment as terminated, then let's talk about that. Contact me as soon as possible through employmentlawyer.ca. You see that address below, employmentlawyer.ca. Phone numbers there, email address there, it's all there. That's assume of course, you're not part of a union. And by the way, everything we talk about on this session only applies to non-union employees. If you are a unionized employee, you have to talk to your union. The union is the only one that can advise you or support you or represent you. There's no exceptions to that, okay? So nothing that we talk about here applies to unionized employees, only to non-union. Okay. So from Heather, I'm a union member, okay? I received bad advice that potentially caused my termination. We have progressed with the grievance. I'm not satisfied with the outcome. Can I proceed? No, you can't. So you cannot hire a lawyer. You cannot do anything. That's the unfortunate part about being part of a union. You have the grievance process. Even if you're not happy with that, there's nothing that you can do. Now, it's been the law in Canada for about 150 years. The problem with being part of a union is that you don't have other options. Okay, you live and die by the union and what they decide, and there's not much you can do otherwise. Okay, Tammy says she was let go because of her injuries. Okay, if you were let go because of your injuries, you're owed severance, and in fact, that could also be a human rights violation. You cannot be let go because you're sick or injured or have a serious medical condition. You can't. That's, again, it's illegal. So beyond severance, you could be owed human rights damages. So you need to contact me, okay? As soon as possible, Heather, employmentlawyer.ca. Let's get to work, okay? No, that can't happen. Okay. Next question from Nice Du. Due to sickness, I went for treatment. I come back after 7 months, and company gave me termination letter, and I show them authentic medical report, but they did not accept it. What is your suggestion? Well, first of all, as you were off for 7 months, the question is, did you just take off, or did you let them know in advance you're going to be off? Did you give them a medical note before you went off saying that you're going to be off for medical reasons? If you went off, you didn't say anything, and then after 7 months you came back from medical leave with a note, it's too late at that point. You were in an unauthorized leave of absence, you're not owed anything. But if before you went off, you gave them a note from a doctor saying, I need to be off, and then you came back with another note, then what you're describing certainly could be a human rights violation, and of course you're going to be owed severance. So we need to talk about that. You could have significant entitlements, but the main question is, did you give them a doctor's note when you first took off time for medical reasons? You can't just take off and then after 7 months come back with a note. You have to give them a note saying you need to be off. Okay. So Gazia, you said you're not part of a union. Okay, great. So you know what to do now. If you want to treat this as a termination, if you want to get severance, as much as 24 months pay, you've been there for 22 years, you want to reach out to me as soon as possible, employmentlawyer.ca. Again, employmentlawyer.ca. Continuing questions here. Belinda, if my employer pays for gas mileage and mileage, should that be factored into my severance? What about if I have paid cell phone? So if they pay for your gas and mileage to get to and from work, then it's not going to be included as part of your severance because you're not going to go back to work when you're off, when you're let go. On the other hand, if they were paying you for gas, even for personal use, so let's say you were driving your car for dinner with your family or to the cottage on the weekend, and they were paying gas for that, then absolutely that has to be included. The average of that has to be included as part of your severance. So for sure. Now, in terms of cell phone, yeah, if you were using your cell phone for other purposes, not just for work, and they were paying for that, then that has to be included as part of your severance as well. And remember here, the lesson is this. When it comes to your severance, it's not just your salary that forms part of the severance. It's all components of your compensation. Salary, bonus, benefits, car allowance, cell phone, all that forms part of your severance, okay? So it's not just your base salary. Very good question, Melinda, thank you. Maha writes, according to the Employment Act, I think you mean the Employment Standards Act, an employer has a right to temporarily lay off an employee without notice. My employer laid me off with a notice that handed me at the end of my day. So no, even though under the Employment Standards Act, an employer has a right to lay you off, that's still something that gives you the right to severance. Okay, our courts have decided that many years ago, 100 years ago, that you have a right to severance. So if you've been put on a temporary layoff, you can treat that layoff as a termination. You, the employee, can make that decision. So if you're on a temporary layoff, two options. Option number one is you wait to be called back to work. You're right, absolutely. Option number two is you can choose to treat that as a termination and get severance. So, Maha, if you've been put on a temporary layoff, if you want now to treat it as a termination, you can. You have to give me a call. We can get to work on that. Not a problem. Employmentlawyer.ca. But those are the options, Maha, okay? Okay. The Dreamer asks another question. Is probation automatic when you start a new job, or does it have to be into an employment agreement? That's another great question. Probation does not exist automatically. Probation has to be created in an employment agreement. So you're never automatically on a probationary period if you start a new job. You're only on probation if you sign an employment agreement that says you are on probation. And even in those situations, depending on what it says, you may actually not be on probation. But the reality is it's not automatic. So a lot of people assume that the first 3 months of employment, for example, you're automatically on probation. Absolutely not the case. Let's see. I want to make sure I didn't miss anything. Sherry, I'm not sure. All you're saying is they did not accept religious exemption, but there's nothing before that, so I'm not sure what you mean. From Simon, next question. I worked for 15 years for 2 employers that are now merged into one company, okay? Would I be able to sue for severance for 15 years or only for the years worked with current employer? Absolutely. All your years count. Unless at some point you signed the document that gave up your seniority or years of service, which you probably didn't, then now you're a 15-year employee. And that means you're owed severance as a 15-year employee. So not just based on the time you've had with the new company. And that's a very common thing with the sale of a business. You work for a company, business is sold or merges, you continue working with the new company. Your seniority in most cases carries through unless you sign a new employment agreement that says that you give up that seniority. So certainly don't ever do that. I'm going to continue answering questions, but let me again give you some more contact information. For those joining us, I'm Lior Samfiru. I'm the employment lawyer. And to reach out to me after the session is done, and anytime, employmentlawyer.ca. Again, employmentlawyer.ca is the website to go to. And before I continue, I want to give you one more address, one more tool to use. One of the most important pieces of information you can have, any employee can have, is how much severance they're owed. Okay, so you may need that if you lost your job. You may need that if you're worried about losing your job. Or you may need that just to have in case something happens. Maybe you're just curious. So how much severance are you owed? Is it 2 months? Is it 6 months? Is it 24 months? Well, here's how you find out. Free, anonymous, easy to use. All you do is you go to pocketemploymentlawyer.ca. Again, see below me, pocketemploymentlawyer.ca. When you go there, you can go there on your smartphone, on your tablet, whatever you want. All you'll see, you'll see a few things. One of the things you'll see is our severance calculator tool. So you go to the severance calculator and you use it. It's free, it's anonymous, it's easy to use. You don't have to put in your name, a company's name, no credit card information, nothing. It's just there for you to use. And you can find out in seconds how much severance you are owed. You can compare that with what you've been offered. And by the way, spoiler alert. It's a lot more than a week's pay per year of service or 2 weeks pay per year of service. You may have only worked for 6 months and you could be owed 6 months severance. Okay? So don't believe me, check it out for yourself. Go to pocketemploymentlawyer.ca. Okay? But right now, I'm live. Keep asking questions, guys. Great questions today. Let's see. Next question is from G or G. I don't know. I apologize if I got it wrong. If an employer will not give severance, even when given a demand letter, then is it best to wait to see what precedent is set with these types of cases before beginning litigation? Well, obviously, every case is different. Without knowing anything about your case, I can't say if you should wait, if you should pursue it, or you should not. Generally, I am not a big fan of waiting. Okay, waiting is wrong to me in most cases. So unless you don't have a good case, why would you wait? Okay, and we don't need to wait for precedents. We know what we're doing. But again, I don't know anything about your specific matter. So that's why I would need to know more to be able to say. Next question, Owl Feather. Owl Feather on YouTube. Has it been put into the Canadian Labour Code that the federal government mandates that employees in federal workplaces be vaccinated? No, that was never happened, and it's never going to happen. So the federal government announced before Christmas that they're going to make or have a mandate for all federally regulated employees. They haven't done that, and they're not going to do it. Okay, it's not going to happen. Next question is from Shauna. When you're on a sick leave, are you entitled to a bonus that was given to all employees? Well, you're entitled to a bonus depending on how that bonus is calculated. If it's calculated based on company performance, so everyone gets a bonus because the company did well, then yes. If it's calculated based on your performance, well, if you were not there, then you can't get the bonus, right? If you worked part of the year, you may be entitled to a prorated bonus. So it really does depend on what is that bonus, how it's calculated, and how it's been calculated in the past. But generally speaking, you don't lose a bonus just because you're sick. Again, depending on how that bonus is calculated. Okay. Ooh, next question. Mirella. Ooh, I don't know if I can read that. It's very long. You know what? I think you need to make that shorter, Mirella. I'm not going to be able to get through that. Or just send me an email separately or contact me through employmentlawyer.ca. Next question from Diane. I was told to stay home during COVID. I did not quit my job. I applied for EI. I was denied because my boss said I quit. I appealed the case and I won. Am I entitled to severance pay? So, well, I guess the first question is who told you to stay home, right? Is it a doctor? If you had a doctor give you a note saying that you can't go you can't work, and you gave that note to your employer and they say you quit, then yeah, they terminated you, and that's your old severance and potentially a human rights violation. So it's a question of who told you and how did you communicate that to your employer, okay? Because all you're saying is that I was told, presumably by your doctor. If you give a doctor's note, yeah, you better believe you're entitled to severance, not even a question, potentially more than just your severance. So Diane, if I understood your question correctly, let me know. But otherwise, let's get to work on getting you severance. You can do that, connect with me, employmentlawyer.ca. Again, employmentlawyer.ca. Next question from Belinda. Why is it that so many people, both employers and employees, say it's only 2 weeks of severance that people are owed? It seems like everyone says that. I agree with you. That's why I started doing my radio shows 10 years ago and TV shows 6 years ago, because people get it wrong all the time. It's wrong. Why do they do that? There's a lot of misleading information out there, but it's wrong. It's not 2 weeks pay. It's not anywhere near that. It's your severance is based on three main factors: your age, your position, and the length of your employment. So the longer you work, the older you are, and the more senior a position you have, the more severance is owed to you. Now, the problem is that so many people don't know that, and when they're let go, they accept the severance that they've been offered because they assume they're not owed anymore. And in fact, they could have been owed an extra $50,000 in severance, which would be extremely easy to get. But they don't know, and they sign it, and once you sign it, that's it. You can't go back. So you know better now. If all of you that are watching me right now, you know better. So you're not going to make that mistake, and you're not going to let your friends and your family make that mistake. If you lose your job, I don't care if you work for 50 years or 5 weeks, okay? If you lose your job, you call me. You email me. You go to pocketemploymentlawyer.ca. You don't like me, that's okay. Go to another employment lawyer. That's fine. But you cannot sign that offer. If you sign that severance offer, that's it, you're done. In 90+% of cases, that offer is a lot less than what you're legally owed, a lot less. Please don't make that mistake. Okay, next question is from Zoe Dash. How long does it usually take before you hear from the BC Human Rights Tribunal? I filed a complaint February 2021 and haven't heard a thing. Yeah, they're very backed up. So I avoid the Human Rights Tribunal right now as much as I can. In most cases, there's other things you can do. We can go through our court system, much better, much faster, much more streamlined. Right now, it could be months and months and months, maybe more, with the Human Rights Tribunal in BC especially, but also in Ontario. So I don't recommend that. I would want to have a chat with you, Zoe Dash, to see, is there a different way we can pursue your matter, okay? You're not going to get much satisfaction anytime soon through the Human Rights Tribunal. COVID has made the situation, they're very bad. They're backed up, they're behind. I can't even tell you when you hear back. Next question is from Sherry. I have worked 13 years and the severance is 8 weeks plus 6 weeks for being laid off. No, it's not. You're owed about a year's pay, 12 months pay. Okay, so not 8 weeks, not 6, not 14 weeks. Absolutely not. So Sherry, that's exactly what I was talking about a moment ago. If you've been offered that, that's a fraction of what you're actually owed. By the way, see below me, pocketemploymentlawyer.ca. That's where you can go to calculate your severance. So yeah, you're owed a lot more than that, After 13 years, you're easily going to be looking at a year's pay. Okay. Let's see. So Zoe Dash, hopefully that, okay, I answered that. Sherry, yes, you know what to do. You got to contact me as soon as possible. As soon as this is done, you contact me. Okay, so Diane says that your boss told you to stay home. Okay, so if your boss told you to stay home, that means that you were terminated when that happened. So yeah, we need to speak right away. You're owed severance, and my concern is that you're going to run out of time, that the limitation period may expire. Don't let that happen, okay, Diane? Contact me today, okay? employmentlawyer.ca. Mirella, okay, I'm on unpaid leave of absence starting February 14th due to my employer not accepting my doctor's note. HR wanted to know the time limit that my family doctor will need for the tests. This doesn't depend on him if I will accept the severance from my company. It means I will accept termination of my employment. So, well, you only get severance if you've been terminated, or you can treat it as a termination. So if your employer says, we're not going to accept your note, we're putting you off on a leave of absence, then you have two options. You either stay on a leave of absence, or you can choose to treat it as a termination and get severance. So there's no third option. You either accept what your employer is doing and hope that they call you back. So that's option one right here. Option two over here is you can treat it as a termination and make them pay you severance. So termination or continue working or accept what they're doing. If you want to get severance, if you want to treat that as a termination, let's talk about that. That could potentially, what you described, be a human rights violation as well. So there could be additional damages owed to you. So you want to contact me as soon as possible. Again, employmentlawyer.ca. So Sherry says, no, 8 weeks, they offered her 8 weeks termination paying 14 weeks severance, so 22 weeks. She's 49 and worked 13 years. Yeah, so you're owed a year's pay, 12 months pay. So if you're offered 22 weeks, that's 5 months. So instead of 5 months, you're owed 12 months. That's more than double, okay? Easy. You know that now. You contact me. We'll get this resolved. A letter or two, we get this done, okay? That's exactly why I told you guys, do not accept that severance offer. Can you imagine in Sherry's situation, if she accepted this, she would have realized after the fact that she was owed more than double what she was offered. Except if she had signed it, there's nothing she could do about it. Okay, so that's where she needs to contact me. So Zoe, you said there's a union involved. Unfortunately, a lawyer cannot help you. It has to be your union. There's no other options. There's no exceptions. The Dreamer. If you give an employer your 2 weeks notice that you are leaving and they let you go before the notice period, are you still owed a full 2 weeks? Generally, yes. Next question, this may be the last question today. How long exactly is the limitation period to sue for severance? If you have been put on an unpaid leave, you just mentioned it could expire. Absolutely. Well, you have 2 years, okay? So 2 years from when the leave started. But generally speaking, again, waiting is not good. Waiting can actually compromise your case in some situations. But there are people, by the way, they were put on a layoff back when COVID first started in March of 2020. And they haven't been called back to work. Well, those people, that limitation period is expiring now, this month, in March of 2022. So if you want to treat that layoff as a termination, and you were laid off in the beginning of COVID, you got to do that now, immediately. I wouldn't even wait another hour. Okay, we need to get going on this. But generally speaking, yes, there's a 2-year limitation period, Simon. So if you've been put on a leave because of your vaccine status, then you have 2 years from that point to pursue it, if that's what you choose to do, to pursue your termination and severance entitlements. Guys, that's the time that I have for today. Really top-notch questions today. Great questions. Hopefully you guys learned something, and hopefully you know some more than you did before you joined us today. If you lost your job, if you've been put on a leave of absence, we need to talk. Okay, as soon as possible, you can contact me through employmentlawyer.ca. We have a huge team that does this exclusively in Ontario and in BC and in Alberta. So thank you very much for joining us. I'll be back next week, but don't wait until then. Contact me in the meantime. We'll talk soon. All the best to you.